Can a consensual encounter still be considered sexual misconduct in Minnesota? The answer is it depends. Sometimes yes, sometimes no. First, we should clarify what arena we're talking about when we talk about a consensual encounter, because the requirements are different. There's the criminal arena, where you think of courts, criminal charges, and court in Minnesota. And then there's the Title IX or school arena. Think of universities, colleges, and high schools. High schools, universities, and colleges usually require what is called affirmative consent, which is a much higher requirement than the criminal law requires. So affirmative consent, there's a lot of training that goes on for students, and each individual university or school has their own definition of what is and isn't affirmative consent, but it doesn't always have to be verbal yeses. So it can be something like, can I touch you here? Yes, you can. That's an example of affirmative consent. But affirmative consent can also be done by nonverbal communications or physical actions that would lead someone to know that they have consent. This is a loose definition. Every school has its own definition. So if you're asking, can a consensual encounter still constitute or mean sexual misconduct in the school arena, what you have to do is look to that school's definition of what consent means. In the criminal arena, in any county, anywhere in the state of Minnesota, the Minnesota statutes define what consent means. And here's what the definition of consent is. I'm just going to read it right off of the law for you. Consent means words or overt actions by a person indicating a freely given present agreement to perform a particular sexual act with the actor. Consent does not mean the existence of a prior or current social relationship between the actor and the complainant, or that the complainant failed to resist a particular sexual act. The definition also goes on to say that a person who is mentally incapacitated or physically helpless, as defined by this section, which means that code in the law, cannot consent to a sexual act. And finally, the definition says that corroboration of the alleged victim's testimony is not required to show lack of consent. So as I indicated, there are many areas in the criminal law where even if a sexual encounter is consensual, that can still be considered sexual misconduct, or what we call in the criminal law in Minnesota, criminal sexual conduct. Here are some examples. First degree criminal sexual conduct says that if the complainant is under the age of 13 and the actor is more than 36 months or 3 years older than the complainant, then neither mistake to her age nor his or her consent by the complainant is a defense. So if they're under 13 years old and the actor is more than 3 years older than them, then the actor cannot claim mistake of age, and the actor cannot claim consent by this complainant that's under 13 years old. You just can't consent to sex if you're under 13 under Minnesota law. There's another example, position of authority. Now, position of authority, there's a whole bunch of definitions or examples of that, such as a coach and a player, a teacher and a student, a therapist and a patient, a doctor and a patient, clergy and someone that they're spiritually advising, and a whole bunch of other examples. A parent in their home where there's a sleepover, for example. So those are some examples of what's called a position of authority. And for example, in Minnesota law, our first degree criminal sexual conduct statute says that even if the complainant is at least 13 years old but under 16 years old, and the actor is more than 48 months older than the complainant, and in a current or recent position of authority over the complainant, then consent is not a defense that's available to the actor. Here's another one. If the actor has a significant relationship with the complainant, so this can be something like blood relatives or relatives by marriage or things like that. So think of uncle, niece, aunt, nephew, grandparent, grandchild, father or stepfather and child, things like that. Those are all examples of a significant relationship. And in those situations, if the complainant is under 16 at the time of the alleged sexual act, then consent is not an available defense. The age thing can get a little tricky, and that's really going to be the subject of another video. Just know that there are many statutes, even with age differences, where consent is not an available defense, at least in terms of guilty or not guilty under the law. So that's of course not to mean that consent is never a defense under the law. There are plenty of times where consent is an absolute defense to criminal sexual conduct or to sexual misconduct in a Title IX proceeding under the law. So it's available as a defense in many situations for school proceedings, Title IX proceedings, as well as criminal sexual conduct under Minnesota criminal law. But just as I said, there are also times where regular consent is not a defense the way that it's applied in criminal cases to Title IX cases. Those usually require affirmative consent. And of course, in the criminal arena, although consent is an absolute defense to many criminal cases, it's not always an available defense in criminal sexual conduct. You have to have a lawyer that really understands and is experienced with Minnesota criminal sexual conduct law to draw out these nuances and inferences, and so you know when is consent a defense or isn't it. Finally, while it sometimes even in situations where consent isn't an absolute defense under the law and the law says consent is not a defense, it can still play in, not necessarily to guilt or innocence if it's not an available defense, but it can play into sentencing or even plea negotiations in cases. Obviously, not in every situation, but I've had many cases where consent, although it's technically not a defense, is still taken into account when an offer is made in the case or when negotiations are being had. So let's say you as a client understand either A, you're looking at the evidence going, I can't go to trial, I'm not going to have a defense, I'm not going to win at trial, but but this should still come into the overall picture of how the case is dealt with. Yes, you should make your lawyer aware of that, and yes, a lawyer can at times use consent, even though it's not available defense, to craft a more favorable plea arrangement or a more favorable sentencing, maybe to avoid prison or avoid doing time or some of the other bad things that can happen if people plead guilty or are found guilty of criminal sexual conduct. I'm criminal defense attorney Ryan Pasiga. I've got a Facebook group that supports the wrongfully accused in Minnesota. I'll post a link down at the bottom. If you have any more questions about criminal sexual conduct or about Title IX proceedings involving sexual misconduct, you can get a hold of me, or you can contact me at arrestedmn.com or at 612-339-5844.